In total, the settlement is roughly $8 billion. And it's important to understand 6 billion of that is for community water and wastewater infrastructure. The rest is for compensation. And the compensation falls into two categories. There's compensation for First Nations themselves, impacted First Nations, as well as individuals in those nations, nations that were subject to drinking water advisories that lasted at least 1 year between November 20th, 1995 and June 20th, 2021. So the claims process for compensation is open now, and we'll be going through both the individual compensation and the First Nations compensation, the timelines and such in more detail later. But individuals have two ways to make claims for compensation, and the deadline for that is March 7th, 2023. So the two ways individuals can be compensated under the settlement are, first, they can submit an individual claim form on their own, or second, they can have their name included on what's called a band council confirmation list. And we'll discuss in some detail what that is. That list means that people don't need to put in individual claims. And then for the communities themselves, impacted First Nations that wish to accept this settlement can do so by December 2nd, 2022. And they do that by having their chiefs and council sign and submit a band council acceptance resolution. The compensation flowing to First Nations as collectives will be a base payment of $500,000 plus an amount equal to 50% of the total paid to individuals of that nation. So the 500,000 will come first, and then the remainder will be calculated based on how many claims are submitted and paid out to the individuals in that nation. And as you'll see from a bit of the background that I'm going to give you, it was important to the representative plaintiffs and to many of the communities that we met with while we were litigating the action that First Nations as communities were being compensated in this. Although individuals had suffered harm, First Nations themselves as communities often found their social fabric torn by the water issues that they faced. And so it was important that that be compensated as well. So by way of background, in 2019, Niskantika First Nation in Northern Ontario, Curve Lake First Nation in Southern Ontario, and Tatasqueyak Cree Nation came each individually approached one of Alana or my law firms for help because they had issues with their water. Niskantika First Nation has had a long-term drinking water advisory for going into its 27th year now. So we, McCarthy Tetro and Olthius Claire Townsend, along with Niskantika, Curve Lake, and Tatasqueyak, started a national class action about this issue to address drinking water advisories in communities across Canada. And the central issue was Canada's failure to take all reasonable steps to ensure that First Nation communities had adequate access to safe drinking water. So after taking the matter to court and having it certified and proceeding, we had a settlement which was finally approved by the courts in December 2021. And the settlement includes, as I've said, compensation for First Nations as a whole, impacted First Nations as collectives, but also individuals. And the period is between November 20th, 1995 and June 20th, 2021. If a nation had a drinking water advisory within that period, it's what's called an impacted First Nation. And it and the individual members of that First Nation will be eligible for compensation. The settlement also includes commitments by Canada going forward to fund construction, operation, maintenance of infrastructure needed to provide regular access to safe drinking water in the homes of those class members. And we made sure that that commitment included a quantity of water sufficient for everyday use, including laundry, cooking, washing, dishes, bathing, etc. So that's the go forward piece. The compensation is about the past, the commitment is about the future. So again, of the 8 billion, 1.8 billion is in compensation to individuals and impacted First Nations, as well as an additional fund for people who've experienced specified injuries, which we'll talk about in some detail towards the end of this presentation. Those are injuries that were suffered during those drinking water advisories. The other 6 billion is to support the actual costs, so not the deemed costs, but the real costs of construction, operation, and maintenance of water infrastructure on First Nations land. And that commitment runs between now and 2030. That hope this infrastructure spending will hopefully lift all of the drinking water advisories and provide more reliable infrastructure to all the nations that have been affected. Also, the Canada's action plan for lifting all drinking water advisories has been included in the settlement as an enforceable commitment. Alongside these things, Canada also agreed in the settlement to modernize its drinking water legislation for First Nations, to include minimum standards, and to create a First Nations Advisory Committee on Safe Drinking Water, which would help to identify issues and advise Canada on the best ways to approach water issues on reserve. Also, there's a fund for supporting First Nations to develop their own governance tools around water. So band bylaws or other governance and planning measures around water will be supported through this settlement. And I'm going to turn it now to Alana to discuss in a little more detail who is in the class and who's not in the class, and some of the nuances around that.
Thank you, Kevin. So to be an individual class member for the settlement, you must be a member of a First Nation and have been alive on November 20th, 2017. And so there is an opportunity for those who were alive as of that date but have since passed to claim, and we'll get into that a little bit later. But if you are a member of a First Nation alive as of that date, there's two categories you can fall in, and it depends on when you were born. So the first is if you were born before November 20th, 1995. If you ordinarily lived on an impacted First Nation during a long-term drinking water advisory that had lasted 1 year or longer continuously, anytime between November 20th, 2013 through June 20th, 2021, you're able to claim compensation during that period. So the 2013 to 2021 period is able for everyone born before 1995 to submit claims and receive compensation for that time. for those who were born after November 20th, 1995, they have a longer period that they can claim for. And they can actually claim back all the way back to November 20th, 1995 through June 20th, 2021. So it depends on when you were born and the dates of the long-term drinking water advisory in your community. But there is a longer eligibility period for those who are born as of November 20th, 1995. And it's just sorry, go ahead, Kevin.
Oh, I was just going to say, some of this can be confusing, and there is a Q&A function. There's a Q&A button at the bottom of your screen, and if you have any questions, please feel free just to type them in there, and we'll try to address them in a general way as we go along. But we also have a question and answer period at the end. So sorry to interrupt, Elena.
No, not a problem. It is confusing, and it goes back to the limitation periods in Canadian law that allow those who are a little bit younger to claim for more years than those born before 1995. And then it's just important to note that regardless of whether your First Nation decides to accept the settlement agreement or not, individual class members are able to submit their claims for compensation. So if your First Nation accepts the settlement agreement, individuals can claim, and even if your First Nation does not accept the settlement agreement, individuals can still claim compensation. And so in terms of individual compensation, there's two buckets that individuals have access to. And so the first is the basic claim compensation. So that's compensation for every year or part of a year that you lived on reserve during the long-term drinking water advisory. And then the second bucket is for specified injuries. So for those class members who really incurred, significant harms from the long-term drinking water advisory, and we'll get into what that looks like in just a moment. But there's two pieces that individuals can claim for, and then as we've discussed, the damages and the amount of eligible years that people can claim for will vary depending on the age and depending on your year of birth. So again, those who are born after 1995 can claim all the way back to that time, whereas those born before that date can claim back to 2013. So in terms of individual compensation, the base claim that we encourage everyone to submit their claims forms for is compensation for any eligible individual based on how and the amount will be based on how many claims are ultimately approved, but it will be based on a formula that considers the type of advisory that an individual was forced to live under. So a boil water advisory, a do not consume advisory, and a do not use advisory will have different compensation amounts associated with them. And the claims formula will also consider the remoteness of a First Nation. So those First Nations that are really remote, like flying communities, will have a higher rate of compensation due to the additional hardships of having to live under a long-term drinking water advisory in those circumstances. And so the amounts of specific compensation for the base claim will be determined once all the claims come in at the end of the claims period. And then the second bucket is the specified injuries. So again, all eligible individuals who are eligible for basic compensation and followed a drinking water advisory but still suffered certain specified injuries will be able to claim money on top of their base compensation. So this money is in addition to their base compensation. And these injuries must have been directly caused by the long-term drinking water advisory. And so this would be either because the individual used the treated tap water while following up drinking water advisory and continued to get sick, or because they didn't have proper access to treated or tap water. And so the same eligibility requirements apply. But if an injury persisted past a long-term drinking water advisory, a claim can still be made. And there's some specific considerations around that we can also discuss. So there are different claims forms for those who are submitting a claim on behalf of someone else or as a personal representative. And so that might be a claim on behalf of a minor child, those under a power of attorney, and deceased persons. And so a representative can submit a claim for a deceased claimant if your loved one had died on or after November 20th, 2017. And so a claim can be filed on their behalf for them having to live under a long-term drinking water advisory and the harms that flow with that. And so this representative of a deceased claimant must be completed by their estate or heirs, and that depends on a number of factors, including whether the class member had a will. So there are some specific considerations under this, but just know that it is possible to claim on behalf of those who have passed more recently. And then this secondary claim form also exists for personal representatives of those with mental incapacity or minor children. So individual class members who are subject to a power of attorney because they might be mentally incapable or had minor children can have their claims prepared by their personal representative. And so if you go to the drinking water settlement website, you'll see that there are two claims forms that exist. So one for adults and then the second form for those with personal representatives with these kinds of circumstances. So that's the individual claimant side of the settlement, but then there's also, as Kevin spoke to, the First Nation side of the settlement. So First Nations can participate and sign on to the settlement agreement, but they must have been an impacted First Nation that provides the administrator with a band council acceptance resolution indicating that they accept the settlement agreement. And impacted First Nations have been vetted by Class Counsel based on the data that Class Counsel has, and a list of them can be found on the administrator's website, which is www.firstnationsdrinkingwater.ca. It's also listed on the screen. So to be an impacted First Nation, each of the following criteria must have been met. So a First Nation that's on First Nations land, so lands of a First Nation that are subject to the Indian Act, the First Nations Land Management Act, or a modern treaty. The impacted First Nation must have been subject to a long-term drinking water advisory. So that's an advisory issued by an advisory body like the federal, provincial, territorial, regional, municipal, or First Nations government, or a government authority, a chief, band council, health authority, executive, regulatory, or administrative body or delegate. And these advisories must have lasted continuously at least for 1 year or longer. And those advisories must have occurred between November 20th, 1995 and June 20th, 2021. So the advisory had to have hit the 1 year mark at some point within that period. And so just going back over First Nations compensation, so every eligible impacted First Nation that accepts the settlement agreement will receive the base payment of $500,000. So that's the total floor of compensation for First Nations. But in addition to that, for base payment of $500,000, they'll also receive an amount equal to 50% of the total individual claims on base payments, so not on specified entries, that have been paid to individual class members living on that First Nations reserve. And so the 50% additional amount that First Nations will receive is on top of what is already paid to the individual members of that community. So for an example, if the total claims made by individuals in a First Nation are $400,000, then the First Nation would receive half of that, being $200,000, plus the $500,000 base payment, meaning that $700,000 would be given to that First Nation for compensation for the collective harms of having to live under a drinking water advisory And so this is really to recognize that many First Nations hindered economic development because of long-term drinking water advisories, impacts to cultural and spiritual practices because of long-term drinking water advisories, and so many others. And First Nations are able to freely use this money as they determine is best fit for their community and for any purpose. And so you can see in the formula below the $500,000 base payment plus the 50% of what individuals claim for the total amount of collective First Nations damages. And I'll hand it back over to Kevin.
Thank you, Elena. So I touched briefly earlier about the go forward, the future commitments by Canada. So it's important to think about them, maybe a couple different concepts. You may have heard the term action plan used around lifting drinking water advisories. So Canada has committed to taking all reasonable steps to remove long-term drinking water advisories, and it has action plans with each individual nation about those. Now, this is now not just a political promise, it's a legal commitment that can be enforced, and that's by virtue of this settlement. And those action plans, the intention there is that they be updated regularly in conversation with the First Nation as circumstances change. But beyond those action plans for just those nations under ongoing long-term drinking water advisories, there's also a larger commitment, which is to take all reasonable efforts towards regular access to drinking water that meets either the better of the federal or provincial water quality standards, whichever is stricter, and which is sufficient to meet all domestic uses, including cleaning, laundry, dishes, bathing, etc. The minimum expenditure that Canada is committed to for that is $6 billion between June 2021 and March 31st, 2030. And that is meant to cover actual costs, the full costs for construction, upgrading, operations, and maintenance of not just treatment plants, but supporting infrastructure, distribution, etc. And the way that that commitment is enforced is through an alternative dispute resolution process. It proceeds like this. If a First Nation thinks Canada isn't meeting the commitment, if there isn't reasonable access to drinking water, it lets Canada know, and Canada has an obligation to consult and to attempt to meet the commitment as soon as possible. Canada will support and pay for the First Nation to get technical advice about what should happen to have the commitment met. And if the First Nation in Canada can't agree on what needs to be done within 3 months, the First Nation can trigger a dispute resolution process, which can get a binding order against Canada, forcing Canada to spend the money to provide that infrastructure. Canada is responsible for paying for the costs of the dispute resolution process, as well as 50% of reasonable costs and disbursements for legal support. And the dispute resolution process is meant to follow the First Nations' own traditional processes for dispute resolution, including it happens in the community, it happens in accordance with the Indigenous laws of the community and the protocols for resolving conflicts. So in addition to that, Canada has committed to making all reasonable efforts to repeal and replace the Safe Drinking Water for First Nations Act by the end of this year. And replace it with a new law that will introduce sustainable water and wastewater systems, as well as introduce standards. So creating a legislative framework for safe drinking water on reserve. And also to support a First Nations advisory committee on safe drinking water, which will be struck to work with Canada and First Nations to support the development and implementation of water policies. In addition to that, there's a governance fund of $9 million. First Nations can come forward and put forward proposals about their own water-related governance tools and bylaw development. And that funding will be available from now until March 31st, 2026. So we encourage any nations that are interested in those initiatives to contact Indigenous Services Canada at their regional office, or feel free to contact us as Class Counsel as well. So in terms of the timeline, it's good to understand what the next steps and next dates are. So the launch date was March 7th, 2022. Essentially for nations, they will need to accept the settlement or not by December 2nd, 2022. Once they accept the settlement, the base payment that Alana was describing will be paid out after the administrator reviews and accepts the Band Council acceptance resolution, and it should be paid out within 90 days of that. Then the remainder, which is an amount equal to half of the total basic compensation paid out to individuals, will be paid out after the individual claims deadline ends, which is in March 2023. They'll need to allow some time for those individual claims to be fully calculated and paid out. So we expect that First Nations will receive the remainder late 2023. So individual class members have until March 7th, 2023 to submit their claims. Basically, once an individual submits their claim, the administrator reviews, either accepts or follows up, potentially for additional information. And that will continue up until the claims period ends on March 7th, 2023. With the expectation that those individual claims will be paid out after the end of the claims period, beginning in around mid-2023. And to be clear, Canada is paying the legal fees of Class Counsel completely separate from the funds that are going to class members. They were negotiated separately after the negotiation of the settlement and did not impact the total compensation available for class members. The compensation, it's also important to note that the compensation paid through the claims process is not intended to be considered income for tax purposes for individuals. And Canada's also committed to make its best efforts to ensure that any compensation received under the settlement will not impact any social benefits or assistance that Class Counsel or that class members would otherwise receive, either from Canada or from the provinces. So I'll turn it now over to Alana, who will do a bit more of a detailed walkthrough of the claims forms themselves.
So before looking at the claims forms, we just want to flag that there are a number of supports available to help you throughout the claims process and in filling out your forms. And the first of which is the Hope for Wellness team, which offers emotional support, and they can help if you're experiencing any emotional distress that might arise as part of this process. And they're available at a toll-free wellness line, which is 1-855-242-3310. They're also available online at www.hopeforwellness.ca. Another support that is available to all class members, individual and First Nation, is the administrator, which handles claim applications and payments. And so for individuals, they can help with any part of the claims process, and they're here to assist First Nations as well. And for individuals, that includes filling out the claims form. So this is a great place to start for anyone looking for more information or who might have a few questions and don't know where to start or who to ask. And the administrator's toll-free helpline is also available here on the screen and is also listed on the website. And the third resource that is available to class members is the Class Counsel team. And so we are here to assist you in this process. There's no charge to talk or speak with anyone who is a member of our Class Counsel legal team. And we can also assist with any individual claims for specified injuries for compensation or any legal questions that an individual might have along the way about these inquiries. The toll-free number for Class Counsel is also listed on the slide, and our contact information is also available on the website. And Class Counsel is also here to assist any First Nations with understanding the settlement agreement and getting legal information. And we can also be retained to provide legal advice on the settlement agreement. And again, all of this is free of charge and will not be any cost to individuals or First Nations. So one of the key aspects of the claims process that might be of assistance to your community is the band counsel confirmation list. And so this is an option that communities have in order to help individuals complete claims. And so this is optional if a First Nation chooses to submit a band counsel confirmation list. Individuals in their community may not have to actually submit their claims form because the band counsel confirmation list will provide those details of who was living on reserve, the dates they were on reserve, the community that they're a member of, and that would alleviate the need to submit an individual claims form for the base compensation piece. But if individuals do want to submit a claim for certain specified injuries, they would still need to complete a form, even if a band counsel confirmation list is completed on behalf of the community. And Deloitte is the administrator, can also provide draft band counsel acceptance resolutions and these forms to help provide assistance along the way. And so under the settlement agreement, First Nations who choose to do these band counsel confirmation lists won't be held liable for doing so if there's any errors or omissions in the list, but it's really a tool that is available to First Nations to provide accessible and detailed information on behalf of their community and those who are living on reserve. And in the event there is an inconsistency between a band counsel confirmation list and an individual claims form, the individual claims form will prevail and will be relied on. So just citing this as one tool that is available should you want to identify members of the community, the dates they're living on reserve. So in the claims form itself as individuals, there are only 3 parts that have to be completed by individual members. So the first is, background details on who you are, things like your birthday, address, contact information, payment information, and a copy of your ID. And this really allows a file to be opened for you as part of the claims process. The second part of the claims form is details on where you live. So this will tell us about the place or places that you lived, and we'll use this information to figure out how long were you living on a reserve where there was a long-term drinking water advisory, whether that First Nation was remote or not, and that's all information that we'll use as part of the formula for compensation. And then the third part that's required is authorization. So this is where you read and agree to a number of terms and conditions. You promise that the information that's provided is correct, and you give us permission to review and decide your application. So those are the really three key parts that need to be completed as part of the individual claim form. But in addition to those parts, there are two other optional parts that you may elect to complete. And they don't have to be filled in unless you are making a claim for specified injuries or if you don't have ID. So part 4 of the claims form is on specified injuries. And this is where you can claim additional compensation on top of the base compensation if you've suffered certain specified injuries that have been serious, long-lasting injuries that were caused by using the water in accordance with the long-term drinking water advisory, or because you didn't have access to clean and safe water because of a long-term drinking water advisory. And so this specified injuries part of the claim really has to connect back to using the treated or tap water. So using untreated water from other sources, like a lake, a pond, or a river, and getting sick from that would not be covered. It would have to be treated or tap water in order to be eligible for specified injuries, and having those injuries link back to that use of water or that long-term drinking water advisory. And then the fifth part, which is an optional part of the claims form, is the sworn or affirmed declaration. And that's where you sign your name and you promise that the information you've given is correct. And that is really because the specified injuries is compensation that's in addition to what people would ordinarily receive under the settlement agreement. And so it also requires a guarantor to affirm that they're recognizing what you're saying is, you're affirming to them what you're saying is true. And so that could be a member of your First Nations leadership, like a chief and council, can also be a class counsel. We can act as a guarantor free of charge and support you with this part of the application. And so that part would only need to be completed if you're claiming specified injuries or if you don't have ID and you're affirming your identity. And so just really trying to make this as accessible as possible. And so aside from the regular individual claims form that we've now just gone through, there's also the other option of completing a representative claim form. Should you be completing this form on behalf of someone who's under a disability, is a minor, or who has passed away. And so this form has additional steps that will need to be filled out. So for persons under a disability, if you're making a claim on behalf of someone under a disability who's unable to make reasonable judgments or decisions on their personal affairs because of mental incapacity, and you're the personal representative person who has been appointed pursuant to the applicable laws in your province or through federal legislation to manage their property or finances. So that would make an individual eligible to complete that claim on their behalf. The representative claims form is also available for those with minor children. So those are children under the age of 18. So you should still fill out this part of the form if you are making a claim on behalf of a child who is a minor. And so there are some nuances in the law, depending on where you reside, that may come into play, but it would be those who are making claims on the child's behalf can do so as a personal representative. And then the representative claims form can also be completed for those who are filling it in on behalf of someone who has passed away. And so there's part 8 for those with estates and part 9, persons with no estate. So the difference between these two is really whether the person had a will or not, and whether there is a person in place who has been appointed the representative of that person. And so these sections will need to be filled out if that is the case that you are filling in for someone. So the real intent of the claims form, it's meant to be, as easy to understand as possible and fill out. And it has been designed to really not re-traumatize anyone, and it has been designed to be accessible and easy to follow along. And so individuals who submit a claim form don't need to submit anything else, just the form. But when you do submit the form, you are asked to promise that everything in that form that you've completed is correct. And then for those who are claiming on top of base compensation for specified injuries, you do not necessarily have to provide supporting documentation or testimony in making these claims, but if you want to and are able to, you can certainly provide supporting documentation as part of this claim. So things like medical records of the injury that you're claiming for and its cause, other records like written records or photos of the injury, a written statement where you describe the injury and its impacts, or oral testimony. So all of those types of supporting documentation can be provided if you're able to. And then those specified injuries do require a guarantor, so a chief counselor, class counsel. And if you're making a claim for specified injuries, you'll need to swear or solemnly affirm in front of a guarantor that those injuries were directly caused by a long-term drinking water advisory. Again, either by using treated or tap water in accordance with the advisory, but still getting sick, or because you did not have proper access to treated or tap water. And so this means you have to complete this form or affirmed declaration in the claims form section. So really just attesting that these injuries were directly linked to the advisory. And I'll hand it back over to Kevin to talk a little bit more about the levels in specified injury claims.
Thanks, Elena. Yeah, so there are two levels for specified injuries, and I want to slowly go through with the time remaining before questions with the differences between them. So level 1 harms are for serious harms that lasted more than a month but less than a year. So the time period is key there. And to be eligible, a claimant needs to meet the following criteria. They suffered significant, prolonged health problems that harmed their quality of life and disrupted their well-being and daily activities. And they must have been directly caused by the long-term drinking water advisory. So again, because the drinking water advisory is about how you use water, the injury needs to have been caused either because the person used treated or tap water in accordance with the advisory, but still got sick, or it was caused because they didn't have proper access to treated or tap water. And so that means that they must have followed the advisory instructions. So for example, if a boil water advisory was in place, you must have followed those instructions and always boiled the tap water beforehand. Using untreated water or using surface water sources, such as lakes, ponds, or rivers is not covered. Injuries caused by that type of water use is not covered. It's really using water in accordance with the advisory. So in addition, the health symptoms must have persisted for a minimum 1 month of consecutive days, up to under 1 year. So, and this is the last requirement, you must have tried to get treatment for the injuries. So the claims form will have you identify who you tried to get treatment from. We recognize in many First Nations, it can be difficult to access healthcare. So if you're not able to get treatment, you can still make a claim as long as you tried to get help from someone, such as an elder, a community health leader, a shaman, knowledge keeper, traditional healer, medicine person, nurse, or doctor. So the definition of who health practitioner and who you could have tried to receive treatment from is quite wide. So level 2 harms are also for serious harms, but they're for ones that lasted for more than 1 year. Again, it requires that there be significant and prolonged health problems that harmed your quality of life, disrupted your well-being and daily activities. And again, it must be directly caused by the long-term drinking water advisory, either because you used treated or tap water in accordance with the advisory but got sick, or you didn't, or you got sick because you didn't have proper access to the water. Again, it must be because it must have happened despite following the directions of the water advisory. And it must be for at least 1 year, and you must have obtained treatment for the injuries from a healthcare practitioner. And again, the definition of healthcare practitioner is quite wide. So the key difference being the length of time that the person suffered the injury. And there's a pretty diverse number of injuries that are covered. There's digestive, which is a common thing that we've heard. Respiratory, dermatological, again, skin conditions we've heard quite a bit about. Liver conditions, neurological or brain and nervous system conditions, bloodstream infections, kidney, tumors or cancer, and then a range of mental health disorders that could be caused by not having access to clean drinking water. So with that, I think that's the content of our slideshow. And I've been attempting to answer questions as they've come up in the Q&A, but now I think we'll open it more generally to questions.